are live. Kind of the reason I'm doing this tonight is going to be, I want to start going over a few things, and there we are. I'll be doing some screen sharing. But in the interim, what I'd also like to do is to start by going over some of the processes from the Mason's Manual of Legislative Process, okay? Because we talked about this on the show more than once. So one of the first things I want to cover in so doing this is going to be, for example, the list of motions, okay? And these are separated by category. And the categories are privileged motions, incidental motions, subsidiary motions, main motions, incidental main motions, okay? So under the privileged motions are the ones reserved for congressional members, okay? Incidental motions are things like appeals, that would be a habeas corpus, points of order, if you want to raise a point of order. The one that I'm choosing right now, the Parliamentary Inquiry, and like requests for information, right? The Parliamentary Inquiry I've filed is basically that. It's a request for information. It is, what process are you following? Because what I'm reading is not due process. This is not due process of law. So, and then of course, orders of the day. So, hey, Kirk, what's happening, dude? I'm answering some questions here about some phone calls and some stuff, some questions I got earlier today. I was going to post this up on YouTube for the non-Facebook viewers who are following the YouTube pages, and we'll talk about that more later. Under the incidental motions, there is also requests or motions for leave to withdraw a motion or question that is under consideration. So, for example, if you had an issue on the table, but you reached resolution and you wanted to withdraw, that's an example of that. Suspension of rules for some immediate purpose. Okay, if there is a rule or rules that are interfering with the motion or the action at hand. Objection to consideration of a question. Manner or order of consideration of questions. Motions relating to a vote. Motions relating to nominations and elections. Motions relating to division of a question. Next one was subsidiary motions. To lay on the table or postpone temporarily. The previous question, vote immediately. Close, limit, or extend limits of debate. Postpone definitely or to a certain time. To refer or commit. To amend. To postpone indefinitely. And then, of course, we go to main motions. The main question presents a bill, resolution, or other substantive proposition for passage, adoption, approval, or rejection. Incidental main motions are the following motions, though they have procedural elements, have the principal characteristics of main motions and take precedence in the same order. To consider motion to reconsider, to rescind, or another way to withdraw. To dissolve or adjourn, Cindy, when no hour has previously been fixed. To fix the time for final adjournment or adjournment sine die. It's SINEDIE. To fix a different time to which to adjourn when a regular time is fixed. Most of these are relative to time. And there is there's a maxim of law that states time rules events. So when we're talking about on the show, when we say, okay, when it comes time to start preparing for how much time are you going to need to present? This is, believe it or not, attorneys do this same exercise. They'll practice in front of a mirror with some form of a time clock or a recorder to see exactly how long it's going to take for them to make their presentation. So, for example, if they know it's only going to take 30 seconds, they'll say, I need 5 minutes. If they know if their presentation is going to take 15 minutes, then they'll say probably 20 minutes, give themselves some extra leeway. This is not uncommon, but it's a requirement for proper presentation. When you decide you are going to go before committee, they're going to ask you, how long do you need? So if you're going to write a paper that's going to be a couple thousand pages, don't think you're going to read all couple thousand pages in the committee. You're going to want to pick up on the finer points of it and basically give a short outline of what's in it. You're going to want to take and offer consideration to the members for rebuttal questions, or even general inquiry questions. For example, did you get this piece of evidence? Who is this player involved? How do they fit in? Those types of things, because there's going to be a lot about this process that a lot of these same people have never done. And it is in the rules, but like us, we have failed to perform our duties under the law to extend due process to government actors. So when we talk about the Constitution as the instrument that creates government, but also the instrument that restrains government, okay, we have to adhere to that process, and that process comes from the Mason's Manual. So now, before I go into the actual document, these are some things you want to know. Okay, for example, some of the questions would be, let me see, the first question that gets asked of me is, well, why are you here? And in my particular situation where there was fraud upon the court, which I could prove, but there was also jurisdiction was assumed when I didn't grant it, okay? And because I didn't grant jurisdiction, that falls under actually the first principle. The first principle being the group must have the authority to take the action, the action or actions it purports to take. Jurisdiction must be given. It cannot be assumed. Groups sometimes assume powers they do not have. So as I progressed through this process in the federal court, and they started to realize, oh, this is the Mason's Manual process. Oh, crap, that's my bad. It was like, yeah, dude, it's been so long since we've seen this, man. Sorry we were kind of, shitheads to you. That's our bad. We'll have to fix that. And it's like, yeah, well, hey, dude, no harm, no foul, right? So, and again, that was a response that when I gave them, they were just like kind of shocked. So, but going back to number 9, there must be no fraud, trickery, or deception resulting in injury to another member. Okay, well, another member of what? Member of the quorum. Well, because there was no quorum, there was no jurisdiction ever granted, right? And because I know how this process works, because of what I've always done, that's why it even seemed foreign to me. So you've got, me standing there looking at them going, what the hell exactly is it what are you doing anyway? And they're looking at me saying the same thing. Yeah, what exactly are you doing anyway? I'm like, well, I'll tell you what, I'll go first and I'll teach you my process, what we call in the private sector loss prevention. And we'll see if we can get to the end of this rascal. And in the meantime, you put a leash on your dog. I'll put a leash on my dog and everybody's happy. Well, I did. They tried to. And as it turned out, we got some local bad actors here, and the whole action of May 1st and all of that garbage and whatever. But it also pointed out two things. Number one, there was validity to the claim. And number two, the ill effects of what them usurping actual due process of law, how it negatively affects the integrity of the court and the integrity of process. Because if they're not following due process of law, due process of the court is irrelevant. That's why there's a maxim of law that clearly states a precedent accomplishes nothing if it solves one problem by creating another. And it's on the cover page of the document. So let me go ahead and bring all of that up, and I'll start to run down through that with you guys, kind of go by the numbers. I see I got some comments here on Facebook because I'm broadcasting this Facebook Live. And I will try to catch some of those at the end. Let's see here. I want SCOTUS question. One of the obvious things that came up in the course of the debate was, why were there so many cover pages? And I said, well, it's a good question. Why are there so many processes? To which I responded, why are there so many processes that don't fit? Right? So it begs the question, under a parliamentary inquiry, what process are you following? Because what you guys are trying to do, just in this one particular incident, talking about the incident of May 1st, we've already generated 4 or 5 different cover pages just on one incident. So you're going to tell me that each one of when I talk about these cases in layers, that's why I construct cover pages the way I do, because each cover page separates the layer, right? So if you want to point out how many layers we're talking about, I said, well, I'll call those cover pages. And they went, well, that's not a bad idea. Kind of give us a starting point. What color is my hair? Yeah, right. Good question. It was gray the last time I looked. So let's see here. Let's go ahead and put that back down as an icon, and let's get this rascal going so I can answer these questions pursuant to the reason that they were even asked. Now, I put the Supreme Court cover page first only in because the court granted me standing. Knowing, of course, that, I'm like, hey, you guys want to play court, you want to fight court, go right ahead. I didn't want to play court, never wanted to play court, don't want to play court. I follow due process of law. I know the difference between Congress and court. You guys want to play court, that is your baby. You can do that without me and, enjoy your whatever the hell it is you do. But because this quote unquote process evolved the way that it did, to me, in the 116th Congress was actually supposed to be page 1. But because the judicial mandate was issued and the court said, well, hey, I want to play loss prevention too, can't leave me out. Like, crap. So I said, okay, I'll put the Supreme Court on top there and, let them have their fun with it. So again, that's what I did. And these 2 cover pages are basically discussing what this mandate says and letting them know that now the court is no longer in disrepute. Why? Because the Bar Association now has a competitor. So as long as the court has a competitive entity, it is no longer in disrepute, because we have the Bar Association doing the prosecution, and now we have an entity that provides for the common defense, right? So now we have both tables, both seats filled for the first time in how many decades, right? And remember, because Justice is blind, and Lady Justice herself being blind, again, hadn't even considered the fact that there was nobody sitting in the defense chair but the defendant. So this again was just me looking at this from the outside, looking in, as seeing these deficiencies. Remember, in loss prevention, we don't just look for things that are there. We look for things that are supposed to be there that are not there. And most oftentimes, especially in the private sector business world, we find more errors that are created by things that are supposed to be there that are not there. And that's basically what I did by presenting a defense mechanism that hasn't been there. Was I pointed out that, look, remember when I said back in my original petition, there's no greater attack on our sovereignty as a nation, not sovereign citizen, sovereignty as a nation, than bad attorneys and bad lawyers or attorneys, or however I worded it, and bad case precedent. Going back to that precedent I spoke of earlier, right? A precedent accomplishes nothing by settling one problem and creating another. Hence the argument we've been having over Roe v. Wade. And I'm not going to get into my political views on that. I have 5 kids, and they're all 5 here. And I think that pretty much says how I feel about it. So moving on. As far as the how I go in and I make my introductions. Okay, again, in the private sector world, we call that a preface or a preface, depending on however you want to say it. And within that, it's okay. You've looked at the cover page. You know what's within the document. Now, what premise or what predicated what I'm about to read? Where did it, go into just a little bit more detail? You'll hear attorneys refer to this as just a brief statement of the case. Okay, I call it a preface. They call it a statement of the case. Word salad, right? And because this is the way I've always done business, and as it turns out, a lot of people recognize the way I do business because I've been doing it so long. It's like, oh, I know what that is. So again, I went in and I said, look, here's me with full authority and standing pursuant to the attached judicial mandate. Remember, keeping in mind, I did not want to play court, right? They drugged me into this monstrosity, and now that I'm standing here, now you're going to have to deal with me. Establishment of loss prevention practice, and through the attached lawfully created corporation, by and through the Florida Department of State to provide loss prevention services to the United States of America Corporation, right? Everybody always wants to complain about it being a corporation. It's there. It's created. You're not going to get rid of it. You've got 2 choices. You can either work within it, or you can try to fight it. If you try to fight it, I guarantee you might as well try to find spit in the ocean. It ain't never going to happen. So my duties include, but are not limited to, okay, this is where I assert my place and standing. And what is my job description, right? My job description are the malicious designs of men must be thwarted. Well, that comes from this maxim of law, right? In the private sector, in corporations, that's called corporate espionage, and various other, bad business practices. Well, I won't even run down the list, too many to name. One of the things that I've also done is integrity of legal or lawful processes issued as unlawful emoluments. And in the private sector, those unlawful emoluments are called business assets. Okay, so when we talk about what I refer to as legal process or lawful process is crap that I've always handed over to the legal department and said, okay, here's my report. You guys go deal with it. Well, now this is me saying, you guys are incompetent and you're stupid and you apparently can't figure this out. So now I have to go do it. So again, now I am dealing with the legal process as well as the lawful process. Okay. Showing them, for example, the stuff I've gone over on the whiteboard in previous videos. I'm sure you'll see them here on YouTube. The targeted customer marketing theory, right? These different business matrices that we've created over the years, that being the most applicable because it shows how the one party is targeted in any one of these kangaroo court proceedings. So that said, the issues that I've already worked in the courts that are in my judicial report that I did after the petition that I had completed with John when he had. I worked on the amicus petition, and he provided that auditor's compilation report. That was our petition. I provided a judicial report based on the 3 cases that I worked, in the federal court at that time. I submitted that. I also submitted the orders that we got from those cases as soon as they came out, right? That's the lawful process, the part that I assumed that the Bar Association was doing, but never did. They never took the orders over to Congress and said, oh, by the way, that piece of legislation y'all challenged, or y'all wrote, it was challenged in court, and it was found, here's what the court said about it. So you either need to repeal it, or you need to rewrite it, or whatever. Again, a deficiency or an integrity of process issue. Because to me, that is the same thing as taking somebody's money at the cash register and not giving them their change, right? Even the court recognized that. Oh, that's a good analogy because it's true. So that's what when I talk about, when I say unlawful emoluments, that's the type of thing that I'm discussing. And then, of course, pyramid schemes, right? Those are unlawful. Those are not lawful processes, right? Sham prosecutions, those are not lawful processes. And other relative defective business practices, whether they're not legal or not lawful, that has yet to be determined, right? So that's where number 2 came in. Let's see, lawful and equal enforcement under the Constitution of the United States of America and the constitutions of the several states pursuant to Article 4, Section 2 of the U.S. Constitution, right? So in other words, there are certain states that contain language about monopolies that other states do not, right? So far, we've discovered Texas and Tennessee are 2 states that do. Advising the court through this process in accordance with established due process of law as I redress my grievances with my legislature, right, as written in the Constitution. My grievance is with the legislature or some action they took that resulted in harm, going back to the Mason's Manual. Let's see here. What did that say? Number 9, there must be no fraud, trickery, or deception resulting in injury to another member, a member of the quorum, right? What was the injury? See the actions of May 1st, right? So this is how I assemble these things. And this is the benefit of having having professional people to deal with, because they recognize this stuff. They've been doing this a long time. So, you can complain about having professionals in there as much as you want, but you can also use that to your advantage as long as you know how, right? Do it reasonably, do it logically, do it ethically, do it all of the things that you expected, but they didn't do. That's the best way for you to go in there and, number 1, prove a negative, right? Because by doing it, you're proving 2 things. Number 1, you're capable. And number 2, the crap they accused you of is so far outrageous that your conduct is nowhere near what their conduct was. So they can try to sell ice to an Eskimo all day long, and it ain't ever going to happen, right? So, again, we talk about established patterns of behavior, thought processes. This is where these legal maxims comes in. The questions to be answered in this case by the court are pursuant to these fundamental principles or maxims of lawful process as follows, okay? One of those is justice comes before liberty, and justice is to be denied to no one. So if they're denying justice, they're denying liberty. In the preamble, let's see here. What did the preamble say? We secure the blessings of liberty. Well, that's in the legislature, not the court. The court came later. Okay? So because these trespasses have been the result of denial of justice, they've denied liberty. Now we have to go back to the legislature right? Where did the wheels come off the wagon, as I always say? Again, that is throughout the process, and that leads us to the questions. And the questions are very simple. How is it anything less than treason to continue to deny the people true justice under the law by not enforcing perjury statutes against government actors in positions of emoluments, which is government, knowing these three most fundamental principles and practices of law? Okay, so we're talking about the deficiencies in the Justice Department. I'm sure if you're paying attention to current events and everything going on in the Justice Department, we have a series of actors. One side, we'll call them the liberal left, is doing everything they can to maintain control of the Justice Department, even though they're not in power, right? They're trying to push this false agenda, this false Russian narrative, so they can twist the meaning of the word emoluments to charge Trump with violations of the emoluments clause. Okay, so now that we actually have the plan laid out as to what the Peter Strzok and Lisa Page were discussing in their text messages as the insurance policy, that's the insurance policy. Okay, moving on. How does the court reconcile or hold accountable the Bar Association in using the Declaration of Independence's declared acts of tyranny like a checklist of things to do in these cases to perpetuate litigation, and those actions not constitute treason on the court? Treason on the court is victimizing Lady Justice. This is also clearly documented, pointed out further in the document, and I'm not going to take you all the way through that. It is posted under SCOTUS question if you guys want to read it. It's in the former Amber and Stephen, which is now called E-Clause, Facebook group. How is Title IV et al. Of the Social Security Act, unlawful emoluments, which of course we know that, anything but practicing barratry or extortion under the color of law? The color of law is that corporation, right? That's those sham prosecutions I've been talking about, right? Unlawfully extorting money from people. All of these trespasses under Title 241 and 242. This is how I'm constructing the questions that lead to those indictments of those actors that are in positions of emoluments, right? The government actors. This is the significance of proper nomenclature. Know what the thing is that you're talking about before you start talking about it, or you end up looking like an idiot, right? So, knowing unlawful incarceration is the end result as clearly established in this case pursuant to the cited unjust conviction law and cited treatises, which I have named, malicious prosecution and false arrest and imprisonments, right? Knowing, of course, what I know about my particular case and what I've seen from many other cases, I decided I'm going to head them off at the pass, which I think I've accomplished pretty successfully here. How is the Adoption and Safe Families Act of 1997, or ASFA, anything less than state-sponsored human trafficking, a death penalty offense as articulated by the World Court? Okay. What legislation did Trump just sign yesterday? Human trafficking legislation. Keep in mind, this document was served in Congress and the court in November of 2018. This is now January 10, 2019, right? So, again, we know under the Ten Commandments, in the language of the court, the language of Latin, the law speaks to all with one mouth. We know this, okay? These are the 10 criteria that the court is supposed to adhere to. And, number 9, here we go with that again. You must not give false evidence against your neighbor. Guess what? There's plenty of false evidence used against me in this case, which of course I've cited. And what is illegal ought not be entered under the pretext of legality, which is exactly what they did. You don't need to be a genius or a rocket scientist to figure this out, right? So again, those principles that govern the procedure of group decision making that I was just reading from the Mason's Manual, I've listed here for you. So you can go down through and read them. I've even included the Black's Law Dictionary 10th edition from page 1446, the definition of what a quorum is. So if you were to open page 1446, here's exactly what that definition looks like. I copied it verbatim. Might as well say I plagiarized it. So if they want to come after me, fine, come after me, but I did give due credit to the Black's Law Dictionary. So, boo boo. Moving on. Let's see here. Here was another, going back to ASFA. That is a special law, correct? Well, a special law detracts from the general law. So if we wanted to assign a legal maxim to something like that, a legal maxim like this one is applicable here. So again, this is just me doing what I do and showing what I show. This filing was also e-filed on 11/16 of 2018, and that would be here in this local court, right? In Marion County Court. And this is me versus them, whether they like it or not. And no, I'm not filing a lien against my ex-wife. I'm filing a lien against the Florida Department of Revenue, which they have since tried to file a motion to strike, which cracks me up. How do you motion to strike a notice? You can strike a motion. Didn't know you could strike a notice. That's a new one. So that's what I said. The hilarity behind this just cracks me up. They literally just make this crap up as they go. And actions like that are only further proof of the kangaroo court lack of process crap, whatever you want to talk about it. You want to go down through and read this and discuss, know exactly how I comprise the logic in preparing the lien, what documents are attached to the notice of lien that went with that filing, right? Well, for starters, the lien document itself, the pyramid scheme, which I'll go over with you guys real quick, the habeas corpus that resulted in the mandate, right? They're going to ask, where did the mandate come from? Well, it came from Judge J.P. Cohen. Well, why did he do that? Well, you want the answer? There's the answer right there. There's the document, right? And then, of course, I included the new Article 12 constitutional provision that the state of Florida voted for, mandating that the court has to not only provide a Bill of Rights for victims, they have to facilitate the relief and the remedy that's due the victim, right? Again, because these things happen, time rules events, there's that maxim of law again. Because all of these things happen in a very short space of time, right? And they're all relative to this subject matter. This goes back to why I filed this as the way I did, not as a remonstrance, but a parliamentary inquiry, right? Because now we're saying, look, we've got all these new processes, right? How do you want to assemble this thing so when we start doing it, it works as the legislature, the legislative intent, right? It works as it's intended. We don't want these bad actor bar members going in there and screwing it up. Why? Because that's what they do with their BS and word salad, and everybody knows it. So if you doubt that, go look at my page and see how they attack me on my page. Personally, I think it's hilarious as hell. Because they're only making this is their Chuck Schumer, Nancy Pelosi moment. Because I swear to God, it cracks me up. The more they attack me and the more I ignore them because I really don't care about them or their opinion. It just exposes them for who and what they are. And it is what it is. So anyway, moving on. That Ohio Family Pyramid Scheme. Here's the pyramid scheme. There's the web address. Don't take my word for it. Congress, go verify that, right? There's the address. Go do that. Here's what it's going to say, or what it said when I found it. Chances are, knowing how these actors work, it's probably been rewritten. I think it's a safe bet to say, because it's now in front of Congress, I would lay money if you went to this web address. I haven't done it. I'd be willing to bet that they've changed it significantly by now. Some of these pages have actually gone away, literally gone away. And of course, this is starting with the 5th District Court of Appeals, the document, the initial appellate brief that led to me getting the mandate, right? And because I've reverse prosecuted this, that's that reus excipiendo fit actor, the defendant by pleading or exception becomes plaintiff, right? How, well, you can't do that. You can't do that. Want to bet? I can claim and exercise any right that I want that exists in law. If you stand there and you accept somebody saying, well, you can't do that, that's you accepting defeat. If you accept defeat, don't be surprised when you're defeated. You stand up, take the stand, or you take your stand and say, I don't care what you say. You have to prove that I can't. So you want to come and participate in the quorum and stand there and yell and scream and whine and complain about why you, quote unquote, think that I can't do this when it comes to me correcting the record, the truth in the record. Again, loss prevention's mission statement. Screwing up the truth in the record is a malicious design. The malicious designs of men must be thwarted, right? So if we're going to put this in front of a jury, whether it be the court of public opinion or 12 members of my peers or a congressional quorum, when it comes to correcting the record and knowing that the truth is the mother of justice, like another maxim of law, what version of reality do you think the jury, the quorum, or even a judge for that matter, whether they like or hate me or not, is irrelevant? Which one do you think they're going to go with? They're going to go with the truth, because it is not only it's the 9th commandment, it's the 9th requirement of the Masons legislative process, and so on, and so on, and so on, and so on. So this does nothing more than pulls out the bad actors who were lying and thieving and stealing and cheating from the word go, because they're the only ones standing there going, you can't do that. You can't do that. You can't do that. Really? Because I've already done it. Don't tell me I can't do it. I've already done it. And not only can I do it for not just one reason, but 2 reasons. Because of Executive Order 13781, where I retasked my fiduciary license, right? That strictest duty of care recognized by the U.S. legal system, to act as a mandatory reporter, right? That's where that comes from, right there. 29 U.S.C. subsection 1109. And because I possess that license, if I find something screwed up in the record, I am actually mandated to report it, right? Let's see, telling the truth. That would be my notary. Maintaining the truth in the record. That's connected to the executive branch. Don't take my word for it. Go verify that yourself. That is 28 U.S.C. 1927, right? So what is the correlation between the 2 of those? Because there is lies and various other untruths in the record, that means that's me proving Lady Justice is the victim. Where else have you seen these 2? That would be in the negative nexus, as soon as I get down to it. I believe it's right here. Kirk calls this the Hallett Doctrine, which cracks me up. Love you, brother. Here we are. 29 USC 1109, right? There it is right there. I did replace 1927 from the judicial report to 18 USC subsection 242 in this instance because there was a definitive trespass. Pursuant to Article 1, Section 11, actually Sections 9 and 11 of the Florida Constitution. You can't jail people for money without due process of law to prove that the money that they're claiming was, or to prove that the money was acquired by fraud. So not only do they got a double whammy, they deny due process pursuant to Article 1, Section 9, and the money that did exchange hands, the fraud actually was committed against me, not by me. So because of that, that's like, oh man, now we got the double whammy on us. And then, of course, Article 2, Section 5, I believe, is the oath of office, but I'd have to double check that. And that goes to the unauthorized practice of law that led to the trespass, right? So in constructing the negative nexus, negative destroys a negative and both making a positive. And let's see, two negatives make a positive. So that's basically what those two legal maxims say. And I think this other one was, you should not do harm, you should not do wrong so that good may come of it. I'd have to verify that. But in so constructing the process, here's the process right there, okay? What's an example of one of the criteria and why is it all negative? Okay. As the only evidence presented in this case dispels the allegations lobbied against me, therefore confirming my incarceration as being unlawful, see the treatise on false arrest and imprisonment. Mentioned on the cover page, right? So I would certainly call that a defective practice. I'm sure many of you would. And of course, I go down through here and explain each value, right, or variable and where it fits. You know, I won't beat you to death with this. We've done this on the show more than once. One thing you guys may want to go as we go through this, I want to point out the power of judicial estoppel. Judicial estoppel is basically a defense mechanism. That's you basically putting your hand up saying, yo, dude, stop, right? You can't do this. This is the judicial way of saying stop. And I'm not open to that page in the book, so give me just bear with me a second here and I'll get in. Are my eyeballs. Without my eyeballs, I can't barely see straight, much less do this properly. Here we go. Here. Figures. Probably not even close to that page. And I'm not. It's okay. I am on the page that I'll be getting to here in just a second. Let's just go right to those. Here we are. Equitable estoppel, estoppel by misrepresentation, and estoppel by negligence. So, I think equitable estoppel is, let me get closer to the microphone so you can hear me. Whoops, crap. Do that. I want to go. I screwed that up. Let's try this again. All right. Reshare and move the mouse next time so I don't screw this up again. Here we are. Equitable estoppel. All right. According to the book, a defense doctrine preventing one party from taking unfair advantage of another when through false language or conduct, the person to be estopped has induced another person to act in a certain way, with the result that the other person has been injured in some way. Okay? So that would be the attorney presenting false evidence that resulted in an incarceration that was unlawful, right? Now, let's go to the misrepresentation. That is an estoppel that arises when one makes a false statement that induces another person, that would be the attorney, inducing the court or the judge to believe, a person to believe something, and that results in a person's reasonable and detrimental reliance on that belief. It's detrimental because it negatively affects the integrity of the court, and it falls under that SMU, or crap made up, as we talk about on the show. And then, of course, negligence, estoppel by negligence, is an estoppel arising when a negligent person induces someone to believe certain facts, and then the other person reasonably and detrimentally relies on that belief. Let's see here, and it's also assisted misrepresentation. Under misrepresentation are also relative to the negligence, which of course I just read, estoppel by misrepresentation. So anyway, kind of give you an idea of how judicial estoppels work and why I have put them in context of saying, look, if you're going to say to the judge or to the court, you can't do that, there has to be a lawful mechanism that does that. It's called judicial estoppel, right? And because I used it as a defense mechanism, right, to stop or keep these attorney actors from repeatedly trespassing the law, the fact that I was able to definitively and properly articulate that led to a mandate in standing, right? And bar members do not want anybody playing court with them. And guess what? I don't want to play court with you. I'll take my job back behind my desk any day of the week and twice on Sunday. Just know that if I have to come back into court and break my foot off in your butt, it's going to happen. So quit doing it, right? Because mathematically speaking, -1 never equals 1, period. Just wrong. Not going to happen. One other such example from the Weaponized Family Court series, right? This was the third party practice. And again, I talk about it here in the rules, Rule 13 or 14 and 37, where I introduce all of this negativity through the Weaponized Family Court, that -1, to prove that all of this crap that took place in here was in fact a negative, right? That's where -1 does not equal 1. That's where crap. That's actually where I got that, right? So again, when you talk about how you comprehensively construct an argument, what are the fundamental principles you're basing your argument on? I call the Black's Law Dictionary calls those legal maxims, right? You want to talk, they said, play nice and you be consistent with court rules. Well, I was already doing that, right? Again, the judge saw that. And so he said, okay, well, yeah, keep playing by the rules. So, okay, I'm doing that anyway, right? And this is what third-party practice, the benefit that third-party practice, providing for the common defense, showing the court all of these negatives. In which court are we talking about? Remember, my target audience was the court of justice, Congress, not the court of the Bar Association or any of that kangaroo crap, right? This is me, how I logically and reasonably, right, would thwart a malicious design. And of course, on the equity scale, the ability to thwart inequities is necessary, right? So that's why I said this was just a very simple way. I wanted to try to go over some of this stuff with you guys and answer some of those questions about Of course, you can read the conclusionary statement. I just went through and gave some brief, here's a couple of legal maxims. Kirk likes this one. The law punishes falsehood, right? Here's one. Common opinion is double, that the proceeding from grave and discreet men, which has, much truth in it, and that the proceeding from foolish, vulgar men, without any semblance of truth in it, right? So I said, talk about comparison and contrast. It's even in the maxims of law. So, and again, me just going back through, where did Lex Scribonia come from? Oh, page 1052 out of the Black's Law Dictionary. The word emolument's been around since the 15th century. Oh, well, gee, I'm shocked. And in 1991, they reinvented the wheel, calling it the emoluments clause. Nice try, right? So that's what I said. This is just me smacking these bar actors around. Why? Because I can, and because I enjoy it. And even the judges know I enjoy it. That's why they sit there and they're just eating their popcorn and laughing. So, again, let's see here. There's various other arguments I've made, conclusions I've drawn, remittance for damages, and, how I construct each document. Memorandum of legal authority. This comes from the court rules. Talk about follow the rules of the court. Okay. Memorandum of legal authority. It's in the rules. Certificate of compliance. That's in the rules, right? What's supposed to be in one of those? Well, in accordance with Florida rule, this was appellate rule, 9.210B8. Brief consists of 11,212 words and 51 pages, not including the crap that came over from the district court at that time. So again, this is just me making my record, and this is who was all served, right, throughout the process, all 6 of them. And or should the court be deficient in showing justice, knowing full well that they are, right? Doesn't mean they're supposed to be, but they're doing it anyway. And of course, me being me, I leave a place for them to make notes. You want to print a copy of it, make notes, go right ahead. Legislation that we've talked about, I think that pretty much about covers it. Yeah, the rest of this is all substantive crap that is not necessarily relevant, other than, let me just go to the attachments cover page. This would be you know what, I got a better idea. Let me use the weaponized family court report, because that is a much better document for me to show you how to construct an appendix cover page. Bear with me just a minute here. I'm going to pull one of those rascals up. Aha. Okay. And maybe, could be. Oh, right here somewhere. There it is. Okay. Now, just for the sport of it, this goes back to I've done this on the show more than once, but I just want to do this for specific as far as how you put your appendix together. Now, again, real quick, here's that preface, right? This is a real quick way for me to kind of capture the, gain the interest of the reader, right? What is it you're about to read, and why would you want to even continue reading it, right? So not only make it truthful and substantive, but don't be afraid to get a little creative in here, because if you do, be surprised that, it's like this is going to be one of those murder mystery novels. This ought to be good, right? So, okay. let's go into the best way to create an appendix. Okay. I've discussed this on the show more than once, but I've never actually really covered it. Obviously, you want to identify it as what it is. This is the attachment. You know, in the preface, I say it's how many words, how many pages, not including appendix, right? This is the appendix. So this is the follow-up. This is an attachment pursuant to the follow-up, and this was the U.S. and E Clause LLC versus Florida, Ohio, and Ohio Congress et al. So this was when I called that meeting between three houses of Congress, and I was acting as I would be standing there in D.C. on the floor of the joint houses, making a presentation not only to the United States Congress but to two other houses of Congress. So, like I said, if you're going to do this, as long as you know what you're doing, they'll pay attention. This was the relative where I go into, okay, now we have the content and what tab it's under. Okay, so we are going to go to, I don't know if I got this. Yeah, I don't have the appendix in here. I'd pull that back up and again. But how I have it laid out here, each tab has a tab cover sheet, right? And the document, this document here, is underneath what it would say tab 1, and then tab 2, and so on and so forth. So when I create these things in the using the Adobe Reader, it automatically bookmarks them appropriately anyway. So all you got to do is come in here and open the bookmarks, and you can go down and you can definitively read whatever tab you want to read. So this was an example of some of the content that was in the appendix that I presented to the houses of Congress. Right, the ABA letter of October 25th, support of HR 1795. That was the challenge against civil forfeiture, right? Even the ABA, which also I have to admit that kind of made me fall over. But even the ABA challenged civil forfeiture as, okay, whoa, time out. That is like a major usurpation of power, dude. Oh, hell no, right? So if the ABA is going to come out and say it, that's one of the 7 danger signs. It's probably significant here, right? So that's why I attached it. Again, my original fiduciary practitioner's report identifying me as me. Why? Because they've seen the report. So when I attach it, they're like, oh, yeah, okay, yeah, I know that guy. Okay, I know. Prohibition on improper guidance, which was the result of that fiduciary practitioner's report, right? Also, the treatise on false arrest and the treatise on false arrest and imprisonments. I've provided them copies of that. Treatise of impeachments. Ooh, wonder where they got that idea. The scamming, the misunderstood confidence man, right? Also effectively known in the legal community as Gorgeous George. Not unlike Curious George, but it is what it is. Ineffective assistance of counsel, sanctions imposed on courts by attorneys who abuse the judicial process, Monell claims, and then, of course, the follow-up in the Altenhofen case, the follow-up in the Malmstrom case, and the preliminary report on the Petrie Blanchard case. So, again, that's why I said this is how I construct one of these documents and why, as I submit these things, they are read, because you can go down through and they could print this. This is page 7 from that report and go down through and say, okay, yeah, or they can just open this tab up and go, okay, yeah, I want to see the follow-up report on the Altenhofen case. So that would be over here. Click on the Altenhofen case. But the reason that I put another copy of this under the table of contents in the document, right? In case the appendix cover sheet would get lost, there would be another copy of it, right? So it's just a way for me to inform them, right? It's also justified and appropriate because it is content, right? It goes right next to the table of contents. To me, it seems logical and reasonable. Guess who else agreed with that? The people who read it. So, and of course, now we can go into the table of authorities and all that stuff. But I wanted to kind of go over that because I wanted to cover the some of those questions. I know we tried to get to them on the show more than once, but we keep getting sidetracked. So I'm going to go ahead and post this on YouTube. So I'll answer the comments in the comments section once I get done with the live stream here. But I wanted to get this out on YouTube because this is going to resolve a lot of the questions and a lot of the issues. And hopefully I won't have to keep answering that same question over and over and over again. So on that note, I dare say I think we're pretty much done here. And I will see you all wherever we see you online or on YouTube. Take it easy.